Morning, everyone. My name is Rob Henneke, General Counsel here at the Texas Public Policy Foundation. Thrilled to moderate this panel here today on revisiting judicial selection in Texas. I want to say hello to y'all here in this room and also those that are watching online. And to kind of overlay how this panel will go today before I introduce our panelists, we'll have discussion for about the first 2/3 or so, and then for sure want to leave time for your questions, plenty of time for questions at the end. But it's my privilege to be here on discussing a subject that I've been in and around for 20 years actually, and I'll explain that in a minute. But really to start off first and introduce our panelists, I'm first very glad and grateful, Senator Birdwell, to have you here to introduce Senator Brian Birdwell, who was elected to the Texas Senate in 2010, and I guess still currently serves as chairman of the Senate Committee on Natural Resources and Economic Development. May change in a couple weeks.
We'll see. So, yes, sir.
And was a graduate of Lamar University, United States Army Command and General Staff College. Senator Birdwell served with distinction in the Army for more than 20 years. And I do want to note and congratulate you, of course, on your recognition, the Senate Pro Tem. And more so than the honor of that selection, Senator, I think the bipartisan comments that your colleagues gave you in that nomination really are a credit to yourself and a credit to the collegiality of the way that the body operates, where members of both sides of the aisle can be great friends and show each other respect. And I think the great example of that was shown through your nomination. So
I was very touched by it. Thank you.
Welcome and being here. I next want to introduce my good friend for a very long time, my former boss, Senator Robert Duncan. I can't stop not calling you that. I mean, it could be Chancellor as well. But Senator Duncan most recently retired as the 4th Chancellor of Texas Tech University. Prior to that, he served in the Texas legislature for more than 2 decades after winning a special election in 1996. I know Senator Duncan because I worked for him 20 years ago. I can say, what I remember about Senator Duncan, and judicial selection was an issue back then, was you were a heavyweight in the Senate, sir. That the issues that we worked on, I remember from that session, post-conviction DNA legislation, workforce, I think workers' comp reform, it really was the case. And when there was a complicated, meaty policy issue that it usually ended up in your office, and everyone recognized that you were one that wouldn't just have the leadership to move it, but really would be in the weeds in it, understand it, and was then able to really understand the best path forward. So it's always been a highlight of my career having worked for you, and I'm so excited to have you back. So welcome, Bob. And then also very grateful to have and introduce with us Mr. Michael Berry. Michael's the General Counsel and Director of Military Affairs for First Liberty Institute, which he joined First Liberty in 2013 after serving for 7 years on active duty as an attorney with the United States Marine Corps. Michael earned his bachelor's degree from Texas A&M University and law degree from the Ohio State University. I really look forward, Michael, to working with you and continue to work with you and the folks at First Liberty. But really, what I would want to highlight is if you need to find in this country where the defense of religious liberty is hard written into stone, it is with Michael, it is with his organization, First Liberty, it is with Kelly Shackelford, and you guys lead the fight every day. Y'all were a mentor to me in building our litigation center here back five plus years ago. Advice on how to do that, but really an example that I look to in how to charge the fight and how to defend our fundamental liberties, but most importantly with what the work that y'all do. So
Thank you.
thank you for being here. I think the way I want to start, we elect judges in Texas. If you were at the breakfast this morning with Chief Justice Hecht, he mentioned, how many judges that we have in the state of Texas. I'm not going to butcher the statistics because I don't remember it, but suffice it to say, it's a lot. And we take pride in that. I mean, there was a reason that was purposefully done. But there's been ongoing debate about whether that is the best way. We're not going to debate that today, but we're going to discuss it. And, Senator Birdwell, we just recently had a Texas Commission on Judicial Selection that was tasked from the last legislative session to take a look at this, unpack it, meet in public and discuss these ideas and evaluate other proposals. And, to frame our discussion here, I'd like for you to ask you to start off in kind of your perspective on judicial selection in Texas, and certainly you were one that supported a continuation of the system that we have here. So
Correct. So in total brutal honesty, I also voted against the bill that created the commission. So Governor Patrick placed me on that committee. Senator Nichols and I think were the two senators of the four that had voted against it. So in putting us on the commission, Governor Patrick wanted to make sure that viewpoint was going to be heard. It really structurally gets to judicial selection as I see it in Texas, as it also relates to the founding of how the Founding Fathers established the judicial body federally, and the dynamics of what we see in the federal judiciary. I don't want Texas to make the same mistake. While that is a tactical consideration, not an operational or strategic, my primary concern is we live under the consent of the governed, not the consent of the appointed. And much of our problems policy-wise nationwide are because too many decisions that are policy decisions or political decisions are being taken to the least representative branch of government. Remember, the Declaration of Independence, which has not been annulled, it is still original law. In the first 15 reasons, those are all structural reasons why we separated from Great Britain. Most people say we separated for taxation without representation. That's number 17 of 27. The first 15 reasons all have to do with the proper role and function of each of the distinct branches of government. 7 reasons are legislative, 6 reasons are executive, 2 reasons are judicial. That lines up with why Article 1 is the legislative branch of government. It's not Article 1, but in the state constitution, the legislature is described first, then the executive, then the judicial. So in the order of importance in the consent of the governed, the legislative branch is the most important, and as Madison said in Federalist 51, must necessarily predominate. Most of the arguments, as I saw it, while they had merit to the tactical and technical proficiency of the judiciary, they were fundamentally, in my view, about the convenience of the judiciary. I'm not interested in the convenience of the judiciary. I'm interested in the consent of the governed, and the governed being able to control all 3 branches of government in Texas, not just 2. That was the primary reason I am where I am. I do believe there's merit to tightening, if you don't mind the analogy because I'm an old soldier, tightening the shot group of judicial qualification. And I know I'm going long here, Rob, and I don't mean to, because I want the other panelists to have time as well. That's why there's clearly merit to some of the challenges in pay that we've addressed, because we're seeing too many judges or people that would be good judges stay in the private sector because of the financial compensation in the private sector as opposed to in the public sector. So the legislature under Senator Huffman's leadership has been doing that, and I know Senator Duncan was working on that even before he left the Senate. So there's merit to that, where we've got to tighten the shot group on qualifications, but ultimately the people that should be judging the qualifications of judges is not the judicial branch. It's the consent of the governed, the same way they judge the qualifications of the executive and they judge the qualifications of the legislative branches of government.
Senator, thank you for that overview, Senator Birdwell. And Senator Duncan, not in response to that, but just in the opposite perspective, keeping in mind, and Senator Birdwell, your comments are well taken, and also recognizing that this was a very divided issue. The Texas Commission on Judicial Selection, when you all voted on this, it was an 8-7 vote, with the 8s carrying to recommend continuing the current system. But I know, for a number of years, Bob, going back to when I worked with you and others like former Chief Justice Tom Phillips, have advocated for a change to a different system. We'll get into the specifics maybe in a little bit, but help us please frame your perspective on making the case for why there would be a reason to change that or to look at something different.
Well, there are a lot of reasons. I want to compliment the commission, because I think they did of any study that's been done of the system, I think this commission probably did the best. They met, I don't know how many times you met, 12, 13 times.
2 in person and the rest by Zoom.
By Zoom, but you had hearings throughout the state that were very successful and brought in a very broad spectrum of perspective about how this, about judicial selection and how we select our judges. We're a different state than we were 150 years ago or 100 years ago, I guess and I agree with the findings of the commission that really were very strong on we need to do something about the qualifications to serve as a judge, and I see that will be something that happens this session probably. I think there's some momentum for that. I think the question is the judicial selection process that we have, where we elect by partisan vote our judges, is that system now outdated in this modern political society and with 29 million people that we have in Texas? And so, or 19 or 20, whatever the number of people is that we have in Texas now. And if you look at that, for example, in what I would like is, if you're going to have a vote, you need to have a meaningful vote. In Harris County, there were over 70 contested judicial elections in 2018. And judges were pushed in and out, not because of their qualifications or that the voters really knew who they were, it's either by their name or by their party. And these pendulum sweeps have occurred in the urban areas for many years, and that does not necessarily lend itself to a quality judiciary, nor does it lend itself to longevity that attracts the types of attorneys that you want to have serving in these judicial positions. So that's one thing. And I think the other thing is, and I don't think in any session, anything that I ever passed in the Senate or got done, always had a voter participation element to it. It's just in a different place. There are different systems and I don't know of any of the systems or most of the systems in the country, and by the way, Texas is only one of 6 states that does this now by partisan election, none of these new systems or systems that now are embraced by many states, they don't get rid of voter input. They just put it in a different place. And they allow for a more important vetting for judicial competence, as well as fidelity to ethics and things like that the voters don't always get when you have 70 some odd contested races on a ballot. So I see that there's room for that, and qualifications means how do you determine if somebody's qualified? Just putting the number of years of service is not necessarily going to be the best way to determine whether somebody's qualified to serve as a judge. You need to have more of an in-depth look at that, and there are ways to do that in a merit selection system that's basically ratified by the voters once those persons have been vetted for competence and ethics and experience necessary to serve ably. The other thing is, and this was really the thing that inspired me the most, is having to donate to a judicial candidate just bothers me. I've tried a lot of cases in my career, and my clients always ask, did you donate to Judge so-and-so? Well, I'm cheap. I probably didn't. But at the end of the day, my opponent might have. And if you look around the country, and we're a large, we really have been fortunate to be able to attract a lot of business interest in our country right now, into our state. But one of the things they always ask, if you're in litigation and you're representing an out-of-state company, they say, well, we understand your system of civil justice in Texas is really warped because of the money that's required to be able to stay in office, and that the judges actually raise money from litigants, mostly lawyers, who appear in their court. And so that's was a problem. I think y'all saw those stats and those numbers as well in the commission. And so I think that's probably the issue as far as the perception of the independence of our judiciary, the fact that we require, I'm not criticizing the judges on this, we require them to go out and raise money to stay in office. And there's just something wrong with a system that requires independence of judicial office holders, to require them to go out and raise money to be able to stay in office from people who would appear in their court. And those are the types of things that we need to address. And I think merit selection is one way to do that. There are many other ways to do that as well.
Mike, I want to turn to you. Senator Duncan, thanks for that overview. I know that First Liberty has looked nationally and researched kind of all, and I don't know if we can say this is the best, but there's differences. But kind of give us a broader perspective on what y'all see as, from your perspective, what's good and what's bad about judicial selection across the country.
Sure. Well, I think to start, I need to use an analogy. And so I have 4 teenagers at home,
wow.
Which explains why I have no money. And I have 2 of those are teenage girls, which explains why I have no hair. But the other day, the younger of my teenage daughters, my 15-year-old, asked me a question, and she said, when you're considering somebody to marry, how do you know when they're really young, right, that they're going to turn out to be great, a great spouse later on, a great partner later on in life? And I said, that's a great question. How do you know? What are the types of things that you would want to know about that person? And I think that is an apt analogy for the way that people can look at the judicial selection process. And to carry the analogy just one step further, for example, if my daughter were to come home and tell me she wanted to marry a guy, and I said, well, why do you want to marry this guy? And she said, because he drives a really nice car. To me, just my opinion, that's the equivalent of somebody saying, well, this person is going to make a really great judge because they went to a great law school. Without more information, I would want to know more and say, well, how did he get this car? Did he steal it? Did his parents donate it to him? Did he win it at Price is Right? Or did he work nights and weekends saving and scraping together every last penny he had to pay off this car, and he paid cash for it? Those different data points tell me lots of different things about that individual that my daughter is, hypothetically considering to marry. So, in the same way, First Liberty's approach is really what is the information? How can we best equip the ultimate decision maker to make a decision on who is going to be a judge, right? And at the federal level, obviously, we have the decision is ultimately made by the president, right? In appointing or nominating at least people to be to the federal bench, and then the Senate Judiciary Committee and the Senate as a whole will then vet and confirm that person. Obviously in Texas, as we've already discussed, we have a partisan election system. So at First Liberty, we began looking, and there's actually a third system I forgot to mention. It's sometimes referred to as the Missouri Plan, which is really a sort of a small group of people that have sort of been supposedly been pre-vetted, and then that group of however many is then put forward to the governor, and the governor will decide from among that pool of candidates. And there are other states that have sort of hybrids or variations of that. I think in Oklahoma, they're actually considering one where it'll be the Missouri plan, but instead of the governor selecting, if the governor decides not to choose from among that pool or just isn't able to, then the Chief Justice of the Oklahoma Supreme Court will choose instead. So there's different variations of the Missouri plan. But looking at those three models, the partisan election model, the federal model of appointment by, at the federal level, the president, at the state level, you would think it would be by the governor, and then the Missouri plan. The one, going back to my analogy, the one that historically has provided the most information to the decision maker, in this case the voters, if you're using a partisan election model, it is the partisan election model. And the reason for that, it was actually counterintuitive to me when I saw this data, is that the judges who are elected typically produce more written opinions and more published opinions and written dissents in cases. And that's very important to an organization like us who litigates every single day because, again, I don't want to know where the person went to law school. That's one very limited data point for me. But if I have a written opinion, I can now see what their judicial philosophy is. I can see their actual approach to how they view the law, the role of the law. And these are things that voters or decision makers, I think, need to know. The more information we can give to the decision makers, the more informed decision they're going to make. And again, one decision, that's just one data point. You need to have as much data as you can to really create that mosaic pattern that then decision makers can begin to see where a particular judicial candidate is on, sort of ideological spectrum, where they see are legally, their philosophical view of the law, how the law plays into society, et cetera, et cetera.
Thank you. Thank you for that perspective. I'm going to turn things around a little bit. Senator Duncan, let's start with you and kind of what I'd like to ask for you, and then I'm going to ask the opposite for Senator Burwell and give Mike you kind of a variation. But to look at the opposite side, Senator Duncan, what would you see as what's positive about the current system that is recognizing that whatever is positive?
Well, I think we have. I do think we have a good judiciary at the appellate level, especially I think in other areas where voters may actually know their judges. They have the ability to do that. Where we get more densely populated areas, I see that as an issue of getting that information out. But that's a hard question because I don't think, and I want to be clear, I don't think that we should take the voters' input out of this. I do think that the voters have, and I think that is a very strong part of our system, that voters have a role in it. The question is what is the best way for the voter to really exercise that right? Mm-hmm. And that's where the criticism I have comes in, is that a partisan election, while it allows the parties to be for or against a candidate, for we may not know why, but they're for them, or lawyers to be for or against them, it doesn't necessarily allow or a really good review. When you have a retention election, you're focused. Does that judge do a good job? Did that judge hear cases? Did he move cases? Did he make decisions? How many times was he overruled by the appellate court? This is the trial judge. Or if it's an appellate judge, we see that we can focus on this judge. In a rural area, for example, in order to remove a judge, you have to put up a sacrificial lamb to go against him. And in many rural areas, who's going to do that? If there's 4 lawyers in town, you go against a sitting judge, that's not going to be too good for your client base. So, but to answer I'm trying to answer your question in the way that I do think that the voter input is a very strong and good part of our existing system. I just disagree so much with the way the voters are, or the position the voters are put in the current system.
And Senator Burwell, kind of the opposite question to you, looking at, you know, Senator Duncan's perspective, or your the 7 colleagues that you know would have recommended a change. What do you see as, or you understand or see as the, you know, the merit of where they're coming from, or where there's a reason we've been talking about this for 20, 30 years.
Yeah, with what Senator Duncan said in his opening comments about campaign finance donations, there are a number of things in that report that I can absolutely agree with the factual statements of how they see. So there's not going to be a lot of disagreement on the assessment of our current circumstance. So there's a number of things that his perspective is, I agree with his analysis of how he sees the judiciary branch. The difference is in the solution better than what we currently have. So as an example, Mike mentioned the Missouri plan. There is certainly some merit to that. The difficulty is this. Let's go back to Iowa several years ago when the Iowa Supreme Court, of its own judicial activity, and they have retention elections as well, of its own judicial or political activity, made a decision for the people of Iowa as it related to the definition of marriage. 7 of those 8 judges were not retained in that election. The problem with the retention election is I can get rid of the judge. I can't get rid of the decision. So the best way to not get those decisions doesn't mean you won't get them. But the best way to not get that decision that you disagree with is for that candidate to stand in front of the electorate before they are in office, not just solely after. Doesn't mean you'll never get a bad decision. And with what Senator Duncan said about involving citizenry, my view is this, and I'm going to use a word here, I'm not attributing it to Senator Duncan, but I want the citizens to be the master of the system and the supreme authority in the system, not an adjunct after other people have set in place an electoral inertia that they didn't have control of. Because look, if there was discussion, and I know I'm going long here, Rob, but there was discussion about the state bar putting together a list of who they believe to be qualified. Look, the American Bar Association and the Federalist Society have distinctly different views of what a good judge is. If you make it the state bar becomes the judiciary's customer, not the consent of the governed becoming the judiciary's customer. So while I can agree with a number of things that Senator Duncan said, the practicality is it may be a bug, but the fix is worse than the current bug you're trying to fix.
No, thank you. I think that really frames where we're standing on this, and thank you for both your perspectives. Mike, a little bit different to you. One, I know that because y'all's sole focus is on religious liberty and the First Amendment, that the majority of your work is in federal courts. I also assume that you have some, familiarity with the federal process, at least because our friend and your former colleague, Judge Kaczmarek, used to be at First Liberty, is now a federal judge in Amarillo. Not getting into the substance yet of the judges specifically, but in looking at, what we've seen the last 4 years, so much discussion about the Trump judges and how President Trump has confirmed, I think, amazing jurists, but lifetime tenure, and that system. What are your thoughts comparing Texas state judicial system versus the federal system and the process that's led to, putting federal judges on a bench?
Sure. Well, there's no perfect system, right? And just like there's no such thing as a perfect judge. Every system is going to have its flaws. And but on balance, I actually think that the Texas system, again, purely because it produces more likelihood of generating information that is useful to decision makers in determining. By decision makers, I just mean either whoever is appointing judges, or if it's a partisan election system, the voters. Getting that information into the hands of them is to me more important, because that will then allow them to make a more informed decision on who is going to be on the bench. And I say that, just as you pointed out, as somebody who had a lot of experience looking at this at the federal level. And because at the federal level, what we all like to assume, I think, that people in the White House counsel's office who advise the president on judicial nominations, people in the Senate Judiciary Committee who do a lot of the vetting, and obviously the nominee has to make it out of committee in order to get to the full Senate for a vote, that they are experts. And they are. I mean, they're brilliant people. But there's only so many hours in a day, and there's only so many people they can hire to do this. And there's just not enough bandwidth and not enough man hours to truly fully vet every issue, right? And again, First Liberty only focuses on the First Amendment. And so what you begin to see is sort of an unofficial and very informal version of outsourcing some of that to where, okay, First Liberty, we can begin to look through literally hundreds of thousands of pages of records, right, of judicial records for, let's say it's a district court judge who is being considered elevation to the appellate court, right? So they may have several thousand pages on their record. Well, think about how many judicial nominees and confirmations there were during the Trump administration. Take a couple thousand pages per nominee and multiply that by that, however many there were, and that's hundreds of thousands of pages. There's no way somebody in the White House counsel's office or somebody in the Senate Judiciary Committee can go through all of that. So that's the problem I see with the federal level, is really just one of pure practicality, that there's no way that group of experts can possibly cover everything. And I'll just say anecdotally, I was often shocked at how often somebody from White House counsel's office or Senate Judiciary Committee would respond and say, we were not aware of this particular decision that this judge had issued. This is potentially problematic. Let's talk about this a little bit more. And so again, and these are the proverbial experts in the room, that they were not aware of something. And it's not because they were ignorant or not intelligent. It's just, again, there's just not enough bandwidth to be able to cover all those bases.
Oh, thank you. I'm going to stay with you, Mike, and then go through the panel on this. And we could have a completely different panel just on this one discussion. But two questions to address at one time for you and to each. One is, what should be the goal in how we pick our judges? Texas selects judges. And related to that, what makes a good judge? What do you think?
Well, those two questions are inextricably, related, right? And what makes a good judge and how you select a judge, I guess I'm speaking, personally here. I want somebody who adheres to the law as it's written, right? And I think it was Justice Thomas who once said, as a judge, if you don't reach an outcome that you personally don't like, you're probably not doing it right. That I might personally disagree with the outcome I reach, but if that is the outcome that the text of whatever law, constitutional amendment, statute, or whatever that is at issue and under review, if it leads me to a decision that I personally don't like, but that's the result that I'm compelled to reach, then you're doing the job of a judge. And that's what I want in a judge. Or as Chief Justice Roberts famously said at his confirmation hearing, a judge who simply calls balls and strikes and not picks winners and losers.
So Senator Birdwell, the same question to you, but I forgot to mention as part of it, one of the recommendations of the commission, I think unanimously or over the majority, recommended increasing minimum qualifications. So in the context of what do we want from how we pick our judges and what makes a good judge, how does the qualifications factor into that?
Right now, the minimum qualification is simply age. This was a rigorous discussion because there was some talk of, well, should they be, board certified here? Well, there's certain types of attorneys that don't get board certified, which you would disqualify from that perspective. It really gets to life experience, and age brings greater life experience to the operations that you are going to perform. So qualification, and I'm going to work with Senator Huffman on this. She's the lead entity. She's the main effort. I'm a supporting effort. As we work on judicial qualification, how do we make sure that we set a standard for judicial qualification that gives a greater amount of life experience, whether that's as a lawyer, in the courtroom, ready to be a judge, rather than simply an age requirement that says once you meet that age requirement with a law degree, you can now go be a judge, but you have not been in the profession long enough to be ready to assume those duties. So while the legislature thinks through that, when we do that, you then put those individuals in front of the consent of the electorate to make the choices of those individuals. I mean, look, you could make the argument that, you know, a member of Congress has to be, you know, X age, the president has to be an X age. The judicial branch, part of the reason for its qualification is that, exactly as Mike mentioned, the law is a box that only the legislature sets with executive signature. And that box only moves as the legislature directs it, either through constitutional amendment to the state constitution, as the people vote for those. I want judges that have, and I'll use a military term here, the self-discipline to ensure that they are only operating with the discretion that the law gives them, not their own policy preferences. That is, I think, the biggest challenge we have at the federal level, and I don't want to see the state replicate that challenge. But I simply think that we need to tighten the shot group, to be more precise with our qualifications, to ensure that the voters that are choosing among people are choosing among people who we say have to be qualified a certain way, but that individual is coming before them as a candidate of their own accord with those qualifications, not coming before the electorate as a candidate because somebody else said they are a good candidate.
Thank you. Senator Duncan, you've tried numerous cases in your career in addition to being a lawmaker. What makes a good judge?
A good judge is a judge that's going to be independent, that will make his decisions. I think all three of us are textualists up here, is what I hear. And we want judges that are going to be able to read the law, understand the law intellectually, be able to discern the complexities of the facts as they apply to the law, and then make a decision based upon their best and honest, with fidelity to ethics, judgment about what the law is as it applies to these facts. An independent judge will do that, but a judge that has to raise money to stay in office or to be reelected because he has to basically appeal to the electorate who got him in office, who are going to keep into office, cannot be as independent as I think all three of us would want a judge to be, or as the third branch of the government is designed to be. It's a check and balance on the legislature and the executive branch. And to do that, it has to be independent, and it has to have the ability to make unpopular decisions. And that is where I think the partisan election system of putting them in place and requiring them to continue to raise money and appeal to their political base to stay in office is where we lose the independence of the judiciary. And so I think that summarizes, and you can say one thing: independence of the judiciary to make sure that the laws and the facts are followed, and not that there's judicial restraint as it relates to policy issues where judges have a tendency to want to go out of the bounds and not follow the law, but follow the popular clamors of the day or the ill humors of society at the time. And so that's kind of my view of it.
So Senator Duncan, let me stay with you, and just, I think let's agree that any overhaul of the judicial selection system in Texas this legislative session is unlikely. But we've had a lot of discussion among all three of you about the money that's involved. It's not a new issue to Texas. I think it was the late 80s that 60 Minutes had the Justice for Sale segment that kind of really highlighted at the time what the Democrat Supreme Court, or majority Democrat, entire Democrat Supreme Court was elected at the time. But in the commission did unanimously recommend adoption of rules to regulate further the role of money in judicial elections. Assuming we're staying in the current framework that we have, what would be a couple of your recommendations as to what some of those new rules should be to make it better?
Well, I think that's, the details in that are going to be very tough because you do have First Amendment issues and things that impede the ability in a partisan election system to do that. So it's kind of hard for me to make a recommendation there because I don't know, I don't think the commission really was unanimous on that either. I think they had I think there was some dissent on that because I think the difficulty is what do you do? I think in 2001 perhaps, I think we did put in a system where we limit the amount that lawyers who practice or lawyers can give or law firms can give. And I think that has worked well, but it still doesn't remove that taint of the political contribution and the influence on the independence of the judge. So it's hard for me to make a recommendation on that wouldn't be in violation of the First Amendment. Although I do think the legislature made a pretty good step, and perhaps looking at those provisions that were done in 2001 and tightening down on those even more could be a situation. You could say if you're going to practice, if you're a lawyer and you're going to be in front of the Supreme Court, you can't give money to the Supreme Court. I don't know if that would pass constitutional muster. Probably not. So that's the difficulty in that. When you have a partisan system and you're going to require judges to be reelected in that system, in a partisan election, a contested election, they're going to have to raise money. And so they're going to either raise money from lawyers who appear before their court or organizations or groups that have an interest in particular policy issues and they want that judge to be loyal to that interest, and that's why they give their donations. So that's the flaw in the partisan process as it relates to money.
Senator Birdwell, if you have any specific ideas, I'd love to hear them. But also, the question I would have is, we elect everybody in Texas. All elected officials have power. So is there a case to be made that judges should be under special rules when it comes to raising money, or should we be talking about all elected officials of every stripe, every level?
Yeah. Let me answer the question that you asked, similar to how Senator Duncan's answered it. I believe, at least my vote for that recommendation was really more an acknowledgement of, I need a deeper dive here, not, I know how I would regulate it. So I think that there's you can give a strategic end state, but how do you get there? That has not been granulated in the report as to how you get there. What are the operational and tactical things I have to do to achieve that, greater transparency? So many of us were like, okay, this is a general statement, but this is its own deep dive, not here's the general statement and here's how we would apply it. There was no such recommendation of here are the things that we think you ought to do, because there were some, as we discussed it, there were some in the judicial branch or the judicial experts that were on the commission that talked about, well, do we do some sort of a taxpayer funded financing? Well, I can tell you those on the legislative side are not going to sign up for having taxpayer pay for judicial elections. So it's an issue to be studied, but there was not any granularity of some thought of here's how we think we fix this. But it's acknowledgement of, I think we need to be looked at, but I'm not sure what the answer is.
Just, it's tough. I agree the difficulty in putting that together with both of y'all's comments. Mike, real quick, and then I'll have one more question before we go to audience questions. But, look, you see a law firm on TV that advertises, and then you see that this judge got $10,000 in contribution running for office. But as a lawyer practicing in Texas, what do you think is a perception versus reality in terms of what that makes the difference? Is it just that it looks bad, or do you think that we have a greater issue of where that is, putting a thumb on the scale to speak intentionally about the way judges actually operate?
Yeah, I think the money that is put into elections, campaign, finance issues, that I don't know that that's necessarily a judicial selection problem as much as it is a campaign finance question, right? And addressing that separately from how are we going to select judges in Texas. And at the broader level, I don't think that altering the system will necessarily get rid of the problem. And I use the federal model as an example here. Campaign finance and elections and whatnot is still an issue. It's removed simply by one degree. And one quick example is, or two examples. Look at the former Senate Judiciary Chairman, Lindsey Graham. Senator Graham from South Carolina was in a bit of a dogfight there, right, in his reelection. And a lot of that had to do with some of the decisions he'd made and the votes that he'd held as Senate Judiciary Chairman. So the campaign finance still showed up, right? The campaign contributions and having to raise money and fighting against people who like what you do and don't like what you do, it still showed up. It just didn't show up for those particular judges who were voted on, confirmed, or et cetera. And it was just 1 degree removed. And let's not forget what happened to Senator Feinstein of California, right? And the calls for her to be removed from the Senate Judiciary Committee simply for participating in the process. So again, I think that those issues will continue to rear their heads. But just, in Texas, we see them, I think, front and center with the actual judges. And to your question, okay, this lawyer or firm donated to this judge. Is that going to be an issue? Well, if the judge is appointed, I think the question becomes, well, did the law firm donate to the person who appointed him? So you're asking the same question, you're just removing it by 1 degree. So that's the way I see it.
Last question, a great perspective, Mike. Thank you. So real quick, one issue this session that may have some momentum is looking at redistricting of the appellate districts in Texas, or at least it's being discussed. And I'm setting aside talking about partisanship outcomes, because I think it's a wash. I mean, this last election, 18 Democrats won some judicial benches. This year, Republicans picked up 2 in Corpus, picked up 2 in Houston. Democrats unelected Justice Rose in Austin, but they lost their races for the Supreme Court. So let's call that a wash. But we've got 14 appellate districts that have been that way for a while. They've got differing levels of workload. Austin sends a lot of its cases to El Paso because of how much work it has. You've got 6 judges in Austin, 3 judges in Waco. You've got differing populations and caseloads. Is it time to rebalance things out? And is that something?
Do you want me to take that first, or?
Well, let me finish with you, Senator Burr.
Okay.
Senator Duncan, let me get your thoughts, and we'll come down.
Well, because they're elected from those districts, it's going to make a difference. And you're going to have a lot of pushback from the judges and that. I mean, that's why we haven't restructured or redistricted in the judiciary in a long, long time. And so, when you get into the rural versus the urban battles, and we're going to have more courts in the urban areas that are going to have the intermediate courts that are going to have precedential value and more opportunities for precedential value over rural. I mean, it's just. There's a lot of issues in the redistricting thing. And so in my view, if you're going to redistrict and maybe even look like at Houston, where you have the 1st and the 14th, where you have 2 appellate courts in one city, and it's a real confusing thing. But I think maybe a better answer, and this is, I don't know, is we need more resources in the judiciary. It's the 3rd branch of the government. Transfer of wealth, family law, property rights, liberty is all being determined by the 3rd branch of the government. Yeah, we really are pretty tight. And what's one of the differences in the federal system and the state system is the federal system, those courts have more resources and the ability to move cases a little faster than we have in the state court system. And I do think that more resources to the courts would be as effective as redistricting and probably more easily done than trying to redraw those lines. I've been there and done that before. It's not that much fun.
Mike, do you have any thoughts about the balance in the intermediate appellate courts here in Texas?
Yeah, I mean, I'm relatively agnostic on that issue, but I will say I think that any redistricting or balancing, I guess in the same way that, when they're drawing up school district lines or building a new school, the concern is usually with the student-to-teacher ratio, right? And so in the same way, I think one of the things we can do to try to avoid creating that backlog of cases is to try to redistrict with an eye towards maintaining a healthy party to judge ratio, right? In whatever district it is. So if it is a rural district, obviously I think it would make common sense to say we don't need to have 20 judges in a rural area of a given population, whereas in a more densely populated urban area, just the redistricting needs to make sense from that perspective.
Thank you. Senator Birdwell, last thoughts to you.
Sure. Let me try to be a bit more precise, if I may. Redistricting is not the right word for the judicial branch as we're thinking about it, because it will not be based on population. Caseload is what's driving this. So let me give just a slight historical perspective, if I may. The last time we redistricted, again, not necessarily the right word, not technically the right word here, was 1983. Normally, in the legislative session ending in a 3 is when the appellate courts, because those are the only ones that would be reapportioned, because district courts are added, they are not redistricted. So district courts, as population growth occurs, are added to a county. Counties can add county courts at law as they're growing in population. Supreme Court, Court of Criminal Appeals, statewide. So it's the appellate courts are the ones that are dealing with caseloads. Since 1983 was the last time the 14 courts had their jurisdictional areas set. 93, 2003, 2013, Chief Justice of the Supreme Court said, we can handle our caseload by transfer. So you don't have to reapportion the courts. Here's the fundamental problem with that. It means the people that voted for the appellate courts in the Beaumont district or the Beaumont appellate region are having their case, because of the volume of cases, transferred to the Eastland court. I'm just generically using transferred to the Eastland court. So when you transfer courts, yes, you're servicing the target, but you are fundamentally breaking the relationship between the electorate and the elected, because the people in Beaumont elected those judges on the Beaumont court to hear the case that came out of the Beaumont district, not have it transferred for the convenience of servicing the target to the Eastland court. So the fundamental customer gets back to, who am I serving? I'm serving the people that put me on that bench, and that's why we need to reapportion for caseload purposes to stop the transfers, so that the Waco court hears the cases that come out of the 10th court, the Fort Worth court, the 2nd court hears the ones that, so that you're not endorsing the failure of having enough judges, because look, resources are an issue. I mean, but we can't spend $1 trillion putting the federal, we don't have the money that the federal government does to be able to do that. But the fundamental issue is we've got to stop breaking little r Republican form of government between those that are elected, those that did the electing, and then have somebody else make the decision. That is the fundamental reason why we've got to reapportion the appellate courts.
Great. Thank you. Thank you all three for that perspective. With a few minutes that we have left, I do want to hear if there's any questions. Mr. Sparks.
I want to start out
You're good.
You're good.
You're on, Mr. Sparks.
It is. I want to start out and say I appreciate the comments that have been made. A little background so you'll understand my question, because I don't know where you go from here, because it's a very difficult situation. But I have been in court as a consultant in oil and gas cases, and I understand it's not always money. Sometimes if you're in a district court and you've got lawyers that come from out of town for one person, your judge knows the lawyers that are in that city. And you can see there's times when it's not just the money, it's the friendship that makes a difference in that situation. The other problem that I see in a lot of our courts is oil and gas is very complicated. I'm sure other civil is also. But a lot of our judges come out of the district attorney's office. They may understand criminal, but they do not understand the civil unless they spend a lot of time. To make a long story short, whenever I ran because of my background, whenever I ran for the state senate several years ago, in a comment which I was asked, everybody there's about 6 of us that were there, and the question was asked, should we elect our judges? I had looked at the Missouri group, and so I said, I don't think we ought to be elected. I thought that Missouri, the way I looked at it, might be a better way to go. Well, I absolutely alienated every county judge. Every county judge. Then I had to go back because you had 20 seconds and you can't answer a complicated situation. Yeah. So my point I'm trying to make is I appreciate what you're doing. I think you got to be very careful. The closer the judge is, like a county judge, I don't think you can take every court on how you do the judges and do the same thing. The closer it is to the people probably needs to be Senator Birdwell where you're at, and that is elected. But when you get to the appellate and you get to the Supreme Court, whether it's criminal or civil or whatever in the state of Texas, how many times people have no idea who's running? And I believe we've got to come up with a way to have better selection and somebody giving us an idea who will be the best judges in those instances. The further away you get from the people, a lot of times I will call my lawyers that I know, because I know several, who do you think is the best judge at the Supreme Court? Most people aren't going to take that time. They have no idea what's going on. So, again, my question is, and I'm not sure I have a question, but my point is I appreciate the difficulty that you guys are working on. I do think there need to be some changes, and hopefully y'all can come up with a good idea and finalize a way that works best for the state of Texas.
Thank you, Mr. Sparks. Those comments are well taken. We're going to do 2 more questions, and then we'll be out of time. So, sir, you, and then Mr. Lambert for the last question.
Well, first I want to say of all the sessions we've been to, I've actually been more educated in this one than any other, and I wasn't necessarily thinking about this subject. Although I have, in the last year or two, my wife and I have had dinner and interviewed several judges, whether it be district or even Supreme Court judges, because we're interested in who we're electing. And I found out one thing, if you ask to see them, they'll see you. But it did strike me strange that who their main source of money is attorneys who they're elected. So I see where you're coming from. So maybe there needs to be a change there. Maybe there needs to be a limit as to how much individual donor can give to judges, which I love that because I love there being limits to you as congressman because it limits how much I can give. That's great. But what I would say, you made the point about the judges being independent, and that's so, so true. They're going to be independent to one of two, either the electorate or to who appoints them.
Yeah.
And I would go with the electorate.
Great, thank you. Let's finish with you. Tim, do you have a final question?
Yeah, it does go back, Bob, your discussion and focus on the independents, and it seemed to me that you're focusing on the partisan part and also the running for election, having to raise money. So my question is, do you see the partisan element of that as a question of independence? And also, if a judge is running for retention, does he not run a campaign? Does he not have to raise money in that situation?
Oh, yeah, I've got a mic, sorry. Yeah, I think you raise a good point on the fact that, I do think that judges are they're biased. All judges are biased, and you can't get rid of that, and there's no perfect system. But I do think that the partisan system basically just requires a judge to be loyal to so many different interests because he's got to get the vote, he's got to raise the money, and it becomes then a contest, a partisan contest, which has really nothing to do with the independence of the judiciary. It has more to do with the popularity, the name, the ability to raise money, to get a good slogan out, and say a lot of good things, but not necessarily live up to them. A retention election, on the other hand, it's not without flaws. It really isn't. But at the end of the day, the voters, it is input to the voters, and it is specific input to the voters. The voters will have an ability not to focus on campaign slogans, but to focus on the record of that judge, and not have the noise and litter of the campaign, the normal campaign things that we see on TV or the campaign slogans or promises and things like that. Raising money is one of the things that's probably easier to regulate in a retention system than it is in a partisan contested race situation because of First Amendment issues. And as I understand, I'm not an expert on that. And so, so to answer your question, no system's perfect. When I ran, I carried two pieces of legislation in this and passed them both in the Senate, and I never had a commission in there because that was where all of the rub or the friction was to be able to get the bill passed. But at the end of the day, the House and the Senate, the governor and the Senate as a confirmation tool in Texas. I'm not talking about the U.S. Senate, I'm talking about in Texas. And I served there, and Brian was chairman of nominations, does a really good job of vetting and bringing together a bipartisan approach to the qualifications of people. So I think that would work in Texas. But I wouldn't be opposed to the commission either. But I just think that process in the Texas Senate is very good. And I took longer and kind of expanded a little bit on your question, but thanks for giving me for the good question.
Thank you, Senator Duncan. We're wrapping up a little bit over time, but I still want closing thoughts from Mike, you, and then Senator Birdwell.
Yeah. First, thanks everybody for allowing me to be here with you today. I've really enjoyed this. My closing thoughts are on the issue of accountability. Right, money is always going to be there and a factor. As I said earlier, whether it's directly in terms of contributing to a judge's campaign or contributing to a person appointing the judge and their campaign. So the way I see it is if a judge shows themselves to not be independent, right, which is something, and I think all three of us up here agreed that we want judges who are textualists, who look at the text and interpret it according to its original public meaning. And if they show the inability or the failure to do that because they are too swayed by the money that's influencing them, then the partisan election method is a much faster way to hold that judge accountable, right, and to get rid of them than if they were appointed. And we've seen that, and we've paid the price for that at the federal level. Particularly, I'm thinking of a specific Supreme Court justice who was, we were all told, oh, trust me, I know this person, they're a true conservative, and they'll vote the right way, and I'm still waiting for it. So if the partisan election method does, I think, It's, again, not perfect. I absolutely agree with Senator Duncan. It's not perfect. No system is perfect, but it does provide a more direct form of accountability if a judge begins to veer off the path.
Thank you, Mike. Senator Birdwell, last words to you.
That could be dangerous, but sure. There's much agreement with my colleagues up here on the stage. It's really more the practical application of what we think the solution is. The center of gravity is the consent of the governed and the electorate having the ability to control the three branches of government. Mr. Puente's comment about independence, when we've had that discussion, you know, when people say, I want an independent judiciary, my first question is always, independent of what? I want them independent of the political appurtenances of the legislative and executive to make sure that there's not I want a certain outcome. But I don't want them so independent that it is of their own personal proclivities that they're deciding that simply because the word supreme is in the name of the third branch of government does not make it the supreme branch of government. So I want an independent, I want an independent judiciary, let the political branches fight the political battles, and I want a judiciary that is technically and tactically proficient and knows the box that it is inside. 75% of our judges, if I may not have the statistic right, but there are a number of judges that are getting appointed by the governor. Now, there's an asterisk there because every time the legislature creates a new district position, the governor makes that appointment. So if you take those out, we still have a high number of judges nominated by the governor. The nomination of judicial officers is absolutely Governor Abbott's wheelhouse. No one, and in my two governors I've had, no one's done it better than Governor Abbott. But you legislate to structure, not to personality. We will not always have Governor Abbott making judicial selections. And he only gets to make the selection of the people that come forward and say, I apply for the job. But you must always have a system that ensures that if a candidate wants to step forward and say, I offer myself to the people of the state or whatever the geopolitical subdivision of the judicial branch is, you must have that system that allow the citizens to make that ultimate choice. So it's not that I disagree with many of the factual elements of what the commission found, it's what's the ultimate solution. There are going to be bugs in it, even in the system we have. But I don't want the fix to the bug to in any way suborn the consent of the governed.
Gentlemen, thank you for your service, your insight today. Please help me to thank the panel.
Yeah.